So today I'm going to talk a bit about a few areas of entertainment law that are probably of particular importance to both screenwriters and production teams. I'm going to talk about a few different copyright and contract issues, examining them through the lens of a standard unsolicited submission release and a DESNY claim under the California case law. So I'll go into some detail about each of these areas, but it's important at the outset to understand the general idea here, and that's protecting your intellectual property. The entertainment industry thrives on intellectual property, and we can certainly debate the quality of some of that IP, maybe a lot of that IP, but it's the lifeblood of the industry nonetheless. Because of its importance, it's critical to understand the different ways that you can protect your IP as you interact with different industry players. So for purposes of this video, I'm going to be talking about literary property, whether that be a treatment or a completed screenplay. So let's get into some of the issues here. So we'll start with some form of literary property. Let's say you've just completed your screenplay. The first couple things you're going to want to do are to register it through the U.S. Copyright Office as well as the WGA. I can go into detail in a later video about the differences between the two, but for now let's just say you want to register your screenplay with both. This is cheap. They're very simple registration forms to complete. You want to use that as your starting point. So now that you've got the work registered, you're going to start to look to shop it around, hoping that you'll garner some interest and that the project will ultimately start to move forward. So where do you think to go? You want to get the screenplay in front of industry players who are going to have the means to act on it. So a talent agency might come to mind. A talent agency would certainly represent the sort of key cast and crew that you would look to attach to your project in order to give it the sort of momentum that it would need. But it's important to note that whether you're dealing with a talent agency or you're submitting the script to a production company, to a management company, or even to an entertainment lawyer, you're going to encounter the infamous unsolicited submission policy. So let's go through a few provisions of a sample submission release form and see what they mean. So the first important provision of the unsolicited submission release form establishes ownership. It says, "I warrant that I am the sole owner and author of said material, that I have the exclusive right and authority to submit the same to you." And it goes on. And that's basically saying, I am the author of the work under the copyright law, and I haven't stolen the ideas in the screenplay from anyone else. The second important provision has to do with indemnity. It's talking about money. It says, "I will indemnify you and your clients of and from any and all claims, losses, or liability that may be asserted against you or any of your clients, or incurred by you or any of your clients at any time in connection with said material or any use thereof." What this is saying, this is basically protecting the production company. It's saying that if the production company ultimately uses your screenplay, they move forward and they work to turn it into a movie, and someone down the line files a claim for damages against the production company, asserting any number of claims against the production company, and those claims arise from the use of the screenplay that you're submitting, that any harm the production company suffers in terms of financial liability, you will cover that loss yourself. You will indemnify the production company. So another important provision of the submission release form speaks to the copyright law again, and it says, "I agree that any part of said material which does not in itself constitute protectable literary property may be used by you or any of your clients without any liability to me." I'll come back to this in a little bit. This goes to, in part, the idea-expression dichotomy in copyright law, the idea that there are elements that are protected by copyright law and elements that are not protected by copyright law. And this is establishing the fact that the production company is free to use as they see fit those elements that are not protected, those elements within your screenplay that are not protected by the copyright law. The last provision of the submission release form that I want to talk about is arguably the most important from the perspective of looking to protect your intellectual property. And it's important to note how broad the language is, but also how it speaks to the risk you're taking by submitting your intellectual property through the unsolicited submission release route. So looking at the language, it says, I recognize that you and your clients have access to and or may create or have created literary materials and ideas which may be similar or identical to said materials, meaning your screenplay, in theme, idea, plot, format, or other respects. It goes on to say that you understand by submitting that you would not be entitled to any compensation should the production company use any of that similar or identical material. So this talks about the fact that the production company is on a daily basis receiving tons of submissions, and they're looking to protect themselves. They may also have a lot of development in-house, and a lot of that development may be as novel as you think your screenplay is. A lot of that in-house development may be very similar to what they're working on, and they want to establish in no uncertain terms that should they move forward with any of those projects, just because you think your project is similar, you won't be entitled to any compensation. So as the submission release makes clear, by signing one, you're taking a fairly significant risk when it comes to protecting your IP. Again, remember, these are very standard in the industry, so it's extremely unlikely that you would be able to submit your script to a talent agency, to a production company, or a management company, or even an entertainment attorney without first signing one. So let's look at a different scenario. Let's say now, instead, you've got a connection to a certain producer, for example, and you're looking to pitch him or her directly, hoping to bypass the unsolicited submission release form scenario. So your connection is able to get you a meeting. You're going to get in there face to face with the producer and hope to convince him or her to take on your project. This is great, but you should be aware that it's still important to protect that IP. So how do you actually protect your script in this situation? You might think of contract law and think, okay, why not just enter into a contract with the producer that would outline the various rights and obligations you would each have with respect to the screenplay? There's certainly no dispute that you can do this. You can enter into such a contract, but that's just not how the entertainment industry works. That would require entering into the contract before the idea was ever pitched, before you ever told the producer anything about your script. This just is not the way it's done. So an explicit contract like that will almost never be the answer. So what is the alternative? The Desney claim is an important area to think about. The Desney claim gets its name from the 1956 case Desney v. Wilder, in which Desney, who was a screenwriter, had an idea for a movie, and he sent that idea to Billy Wilder's office. To just provide a really high-level summary of the case, Wilder's secretary asked Desney for a shortened synopsis, which Desney gave to her over the phone. He also explicitly said that he expected payment should the idea ever be used. Well, fast forward and a film later comes out based on the idea that Desney had pitched, so Desney brought a claim for damages because he had never been paid for that idea. The central issue that case resolved was whether there can be a protectable property interest in a mere idea. The answer was yes, and that has been upheld in California ever since, all the way up to the 2011 Ninth Circuit case Montz v. Pilgrim Films. Desney claims are usually brought by plaintiffs who say that they pitched their idea to a producer or to a studio, and that producer or studio later used the idea without paying for it. The important idea is that there is an implied understanding at the time the idea is actually pitched, that if it's later used, it will be paid for. So at this point, it's important to note what we're not dealing with. We're not dealing with copyright protection, and we're not dealing with an express contract. Under the federal copyright law, ideas are not protected. Only the expression of those ideas are protected. This is the idea-expression dichotomy I mentioned earlier. And we're also, like I said, not dealing with an express contract. A Desney claim revolves around an implied contract, which is an unwritten contract whose terms are implied by the circumstances. And that's the key here. If the circumstances imply an agreement that an idea you pitch will be paid for by the producer or the production company if it's later used, then you're still protected. And finally, a quick note on the Montz v. Pilgrim Films case. This was an important case not only for affirming the ability of plaintiffs in California to bring DESNY claims, but also for the copyright preemption arguments that were raised. So in that case, the defendants had argued that state contract law, California contract law, that was allowing these claims for breach of implied contract based on these allegations of idea theft, the DESNY claims, should be preempted by federal copyright law. They were basically saying that DESNY claims were nothing more than backdoor copyright claims, and that plaintiffs should not be allowed to use them in that way to really circumvent the limits that Congress had placed on copyright protection. Well, the Ninth Circuit rejected the preemption argument, and it said that there's an element in DESNY, and this is what the ruling was really based on. There's an element in a DESNY claim that is not present in copyright law. And an implied agreement for payment for the use of a concept is what separated the two. So under copyright, there is no need to license the concept because the expression itself is licensed. So the Ninth Circuit reasoned that DESNY claims in California involve a wholly separate, even if implicit, but a wholly separate agreement to buy and sell the underlying concept. Thus, the DESNY claims can proceed separate and distinct from any copyright claims. So the majority in Montz was really clear and open about why it believed that DESNY claims are so important, and that was to protect the little guy. And there's an important quote from the case that I'll close with. The DESNY innovation serves to give some protection for those who wish to find an outlet for creative concepts and ideas, but with the understanding that they are not being given away for free. Without such legal protection, potentially valuable creative sources would be left with very little protection in a dog-eat-dog business. So to wrap up, I just want to recap a few of the important steps you should take when it comes to protecting your intellectual property. First, you want to be sure that you register your screenplay with both the U.S. Copyright Office and with the WGA. You want to be sure you understand the implications of signing an unsolicited submission release form. You want to know exactly the language you're dealing with and the implications moving forward. If possible, you want to try to enter into an express contract with respect to your screenplay or an idea that you're pitching, but remember that this will very rarely be an option. So in the alternative, you should go into pitch meetings with a DESNY claim in mind, and you want to look to establish certain factors that we talked about. So you want to establish your ownership of the work, right? That you were the author of the work. You want to be sure that it's clear you're not disclosing the idea or making the pitch for free. You want to make clear that you expect to be paid should the idea later be used. And finally, you want to establish that the offeree, the production company, for example, the person to whom the idea or screenplay is being pitched, voluntarily accepted the pitch, right? That they had an opportunity to turn it down, and that they understand you expect to be paid should the idea or the screenplay ultimately be used in the future, and that at the time of the pitch, they had a reasonable idea of the value, right? They had an understanding of the market value. And of course, it's always smart to follow up in writing.